remember, Tom, I thought that was years ago. It's very odd, isn't it? I haven't worked in chambers since March.
Well, we only come back October from March.
Really?
It's all a bit weird when you come back, isn't it?
You might work in chambers.
No.
I don't think we'll ever get a near normal one, do you?
Well, it's certainly not going to be for a couple of years at the earliest.
Well, it's just, we've all become so used to working remotely now. I come in for conference, we're all used to doing it on Zoom.
That's fine. Well, there are quite a few people who do work in chambers.
Yeah.
So, fairly odd.
Well, I mean, obviously, there are some people who it's not convenient for them to work at home. Right.
And the staff are okay about being back in. Because you have a choice really about being back in, don't you?
Not at the moment, no.
Of course, government wants to ensure that courts, things like that are operating.
I was asking if they could shut the courts a little bit earlier, but trouble safe for their own.
Most things are travelling in and out, is it?
That's the worst part.
Yeah, absolutely.
We're ready, yep. Silence, court rise. Reviewing the matter of the Royal Borough of Kingston-Upon-Thames and Borough.
Yes. Good morning, Mr. Macy. Good morning. My Lord, I appear with my learned friend Miss Perec for the appellant, and my learned friends Mr. Westgate, Queen's Counsel, and Mr. Cleaver appear for the respondent. Well, this is an appeal from the order of Mr. Justice Morgan, wherein he decided that for a period of 14.5 years, the appellant had charged the respondent in excess of the maximum charges under the Water Resale Orders and order repayment. And it's common ground that in that entire period, the respondent had been charged the same amount that he would have been charged by the water undertaker, but nonetheless, by operation of the resale orders, he'd been overcharged. And as my Lord knows, that conclusion was based upon the judge's interpretation of an agreement which we're calling the 2003 agreement, and in particular his conclusion that it was one under which Thames Water agreed to provide water and sewerage services to the appellant to a number of unmetered premises for which it agreed to make payment.
All right, can I just mention a couple of matters
My Lord, yes.
before you get in full flow? We take the view that this appeal, leaving aside the question of interpretation of some provisions of the tenancy agreement, really turns on a very limited number of points of principle about interpretation.
Yes.
And some specific points of interpretation on the 2003 agreement. All issues of fact, so far as we can see, have been found by the judge. So not concerned with that. We have all, obviously all three of us, have read the judgment and the skeleton arguments. We're familiar with all the statutory legislation and the orders. So you can assume that we are totally familiar with, as it were, all the statutory and factual framework for the issues of interpretation. The critical ones, obviously, from your perspective, being should the judge have taken account of the pre-2003 agreement agreements, if you like, and if he had done so, would that have made a difference? I mean, those are the two
Yes.
major points from your perspective. And then there are various issues that arise on the 2003 agreement, reference to commission, VAT, and then there's an entire agreement clause and so on. But these are all relatively confined points, it seems to us. So I just wanted to encourage you to concentrate on those confined points. We actually see no reason why, giving everybody a fair hearing, we shouldn't finish this today. So what we would like you to do is to, for both of you, in the first instance, to deal with those issues of interpretation relating to water and sewage supply, and leave the question of the interpretation of a limited number of points on the tenancy agreement afterwards. We'll come to those as and when we need to.
My Lord, yes. I'm very grateful, my Lord. Of course, my Lord, if we're wrong, essentially, if we're wrong on our first ground, that is, looking at the previous agreements to gain understanding for clause 3.2 and 3.6 and 4.2, then essentially we are in extreme difficulty.
Yes.
And then the tenancy agreement point falls away.
Quite.
And my Lord, we do recognise, of course, when granting permission, my Lord, Lord Justice Lewison did note that the judgment was clear and cogent, and my Lord, we recognise that permission has been granted because of the wider issues and the number of local authorities who have similar agreements. The question, of course, is, well, have they simply all made bad bargains and tough, or on a true interpretation, you know, is there something different? Yes. We're well aware of that.
And as I understand it, if Kingston was a water reseller, it's accepted that Mr. Moss has been overcharged.
Yes, that's correct. Yes, it is. Well, what I propose to do, mindful of the very helpful indications you've given, and I will therefore speed up during the course of the submissions, and I will endeavour to finish by the short adjournment.
Thank you.
So what I propose to do is summarise the principal points of our submissions, take you directly then to the 2003 agreement in its terms, because I can't avoid those, obviously. Thirdly, to look briefly, mindful of my Lord, at the relevant statutory provisions. Then, again briefly, at the evidence in relation to the previous agreements, in particular the 1977 letter. And then finally, make my submissions insofar as I haven't already done that over the course of my address.
Yep.
My Lord, so far as our submissions, which we recognise is an essential step, is that we do say that interpreting the agreement, the judge was required to take into account the terms of the prior agreements dating back to the 1st of April 1978 with the Thames Water Authority. And we say that this was both admissible and also provided relevant material necessary for the proper interpretation of that agreement. And we will say that at both a particular and a general level. At the particular level, they provided the explanation for the undefined term commission in clause 3.2 of the agreement. And we say that properly understood from the prior agreements, commission was a sum paid in return for the appellant collecting the charges from each of the tenant occupiers of the unmetered premises, there being an obligation so to collect. And also it included an element for non-recovery, because as my Lord knows, the risk of non-payment was to be borne by the appellant authority. If that's a correct submission, then this provided a ready explanation for clause 4.6 of the agreement, which required the appellant to send a VAT invoice to Thames Water for any VAT payable on that commission.
Is it suggested that such VAT invoices were in fact rendered?
My Lord, there was evidence before the judge, which does refer to, that VAT invoices were rendered, but as he indicated, these couldn't be taken into account in determining the true interpretation.
Because they're post-contractual.
My Lord, that's right. But of course, it was common ground below and here that VAT would not be payable on a discount, and VAT could only be payable if there was some form of taxable supply undertaken by the appellant for Thames Water's benefit. And we say that if we are right in terms of the definition of commission, then that provides an explanation for 4.6 because the appellant was undertaking a collection service to benefit the water undertaker. That's at the particular level. At the general level, we say the judge should have concluded that the agreement before 2003 was a contract of agency made pursuant to the appellant's long-standing powers to collect and recover charges on the undertaker's behalf. So that is ground one. And if we're wrong on that, as I say, realistically, there's not much further we can go. As to ground two, if we are right, then it follows that there are express clauses in the 2003 agreement that do suggest the relationship was one of agency. But of course, I accept there are other clauses that are entirely supportive of the judge's interpretation. And therefore, in that case, the court would have to determine, well, what is the correct characterisation of this agreement, given that there are clauses going one way and others going the other. And we say the judge should have concluded this was a contract of agency and not one, the provision of services by Thames Water to the appellant, taking into account the following matters from the wider admissible context. Firstly, the 2003 agreement, although entered into on the 14th of January 2003, was dated to take effect from the preceding 1st of April 2002. And that was without any consequential accounting provisions in relation to the 9.5-month period already gone. And over a period when the authority will have been demanding charges from tenants every week in the same way as it had been doing for decades. And we do say that the fact the agreement was stated to take effect retrospectively does strongly suggest it wasn't intended to affect the change in the parties' pre-existing legal relationship. The second matter of background context, we say, is the Water Resale Order itself. It was made on the 28th of February 2001, and we say it would have been reasonably available to the parties as at December 2002 when Kingston signed the agreement. And if we're right on that, we seek to draw 2 points from the Water Resale Order. Firstly, it would have made no commercial sense for the appellant to enter into an agreement for the provision of services by Thames Water if this order was to apply, because the commission and the discount it had negotiated would have to be given straight back to tenants, and it would make a bad bargain. And secondly, if the resale order did apply, it would change the basis upon which the occupiers were then to be charged by the local authority. Because, as my lords know, we'll see later, the Water Resale Order set out formulae under which a reseller is to demand charges from the person. And it is not open, or it would not have been open to the appellant simply to have knocked off the commission and bad debt allowance and then charge the occupiers accordingly in accordance with the same formula as in the charges scheme. It would have to use one of the mechanisms which could have led to a very considerable redistribution in the charges flowing from an agreement to which the occupiers were not party and had no notice. And I'll obviously have to take you to that to make good that point. And we say it is highly unlikely that the parties to the 2000 agreement would have intended such a consequence. And then the third point of background is the fact that if this was an agreement as the judge characterised, it would have resulted in the removal of 4 statutory rights of occupiers under the Water Industry Act 1991, which would have depended upon the definition of consumer. And again, we say it's unlikely the parties would have intended that. So that's how we principally put ground 2. If we are wrong on agency, then we do say in the alternative that the 2003 agreement gave rise to an agreement sui generis, under which the appellant was collecting and recovering charges on the undertaker's behalf. We recognise that that submission requires the court to consider whether such an agreement, short of agency, is capable of existing. And as my lords know, my learned friend's position is that it's not, that the provision is simply one of vires. We don't agree, but if we're right on agency, we don't need to go that far, and we recognise that whichever route we take, there are obstacles in our way, and so this is the way in which we think it is better to frame our case before this court. And finally, we don't maintain any arguments based upon assignment. Our case has always been this is one of agency. That's what we say about the clauses. If we're wrong on agency, stroke acting on behalf of, it's hard to see how we could win on equitable assignment. So that's ground 2. Grounds 3 and 4 almost follow from that, because if this was not an agreement made as the judge characterised, then we don't think it to be doubted that there's no question but the appellant would have been a reseller, and therefore it wouldn't have recharged. And then, as my lord knows, ground 5 is discrete tenancy point.
Yes. So
that's how I will propose to say. Can I then take you to the agreement, rather than trying to wait an hour and a half and frustrating the court? If my lord, it's in the call bundle at tab 11 at page 153. And I know my lords will have considered it a number of times, and it's not very long, and no matter how many times I read it, I can't find clauses in there that I'd like to. So my lord, it's 11 pages, and we accept that but for clauses 3.2 and 4.6, it is not particularly helpful to submissions that we are making to the court. And as my lord sees, parties are described, and Kingston-Upon-Thames is described as the customer, and as the judge noted, customer or potential customer is a term defined by the 1991 Act as any person for or to whom the company provides any services in the course of carrying out the functions of a water or sewerage undertaker. And it is right the judge referred to that language as suggesting that Thames Water was providing a service to the authority. We say that one can't really draw that conclusion from the term used of customer. And we would make 4 points to deal with that here, if I may. Firstly, that the recitals which do define the parties do not define the local housing authority as a customer by reference to the Water Industry Act itself, but choose to define it by reference to the Housing Act 1985. Secondly, the second recital does not speak about services provided to the customer, but to services provided to premises managed by the customer. So recognising that there are other interests involved. Thirdly, customer is, we would say, a label, and if, of course, one can't take labels at face value, just as one can't take the reference to commission in clause 3.2 at face value. And indeed, in Jones, Mr. Justice Newey pointed out that these two labels counterbalanced one another. Just for my lords, that's paragraph 52, Roman 9 of his judgment. And the fourth point is that Thames Water, in fact, referred to the appellant having a customer account back in 1990. So it's clearly not a term that was, at least in the past, defined as being a term of art. So with that, that's the word customer. My lord, recital 3 provides the provider and the customer have agreed the customer will pay for the services in respect to the sum of the premises in accordance with the provisions of this agreement. Now, on its face, that is supportive of the judge's analysis, but of course, the important words are the ones in accordance with the provisions of this agreement. So one can't take very much from that. Then turning to the substantive terms, clause 2.1 is clearly problematic from our perspective. The customer shall pay for all the provider's charges, in respect of the services provided to the unmetered premises. On its face, that is an obligation to pay, come what may, and consistent with the provision of services and the payment for them. Then one sees the reference to the charges scheme in clause 2.3, and then one comes to clause 3. And clause 3.2 provides that following the deductions under clause 3.1, the balance of the charges were reduced by a further 9.3% by way of the Customs Commission. Now, the word Customs Commission is arguably out of step with clause 2.1.
Can I just ask you about clause 3.1?
My lord, yes.
As I understand this clause, the 3.5% reduction to take account of voids is a fixed percentage, irrespective of the number of voids that there actually are.
That's correct.
And if a property is empty, there is no occupier
That's correct.
who is liable to pay any charge, whether this is an agency arrangement or otherwise.
That's right.
So the local authority may be paying water charges in respect of a property where no one else could possibly be liable to pay.
That is correct. That's correct. And as one sees from the 1977 agreement, this arose even then out of administrative convenience, just a way of doing it, rather than having to account for 5,000 properties and voids. And as my lord also knows, this purely deals with standard voids, intra-tenancy voids.
Yeah.
So, my lord, clause 3.2 is arguably out of step because of the use of the word commission. But the reader isn't helped because that term is undefined. Unlike any of the other terms, for example, you see charges are defined, tariffs are defined, but not customers' commission. And so one is left with wondering, what does this 9.3% reduction represent? What's it for? Why is there an entitlement to it? See clause 2.2. And indeed, clause 3.2 could have simply ended after the percentage 9.3%. It didn't need to say anything more. It could have said by further deduction. So the parties have chosen to use this phrase, customers' commission. And one would suppose from its inclusion that the parties certainly knew and understood what customers' commission meant, and that it required to be referred to in this agreement simply by referring to 9.3% or deduction. But they haven't done anyone any favours by the way in which the agreement is drafted, because you simply don't know what it is.
Well, I think you've just accepted that the words by way of the Customs Commission are just a label, because in terms of the substantive operation of the clause, those words don't alter it.
Well, no, but that's right, they don't, but it is for something. I mean, if it was a pure deduction, a discount, we would suggest it would have said that. But it doesn't. A specific term has been used. When one moves to the payment terms under clause 4, clauses 4.1 to 4.5 are consistent with this being an agreement to provide services by Thames Water. But then one comes to clause 4.6.
Just pause a moment at 4.2.
Yes.
Payments are made from April to November. Presumably from December to March, nothing is paid.
That's right, my lord.
Although the tenants will carry on paying their weekly water charges.
My lord, that's right. And what one sees is the 8 instalments was the same provision under the preceding agreement. It started off as 2 payments in 1978, then it changed during the course of that. But that's right. There is, and I think that this was similar to the position in both Thomas and Jones, where the authorities made payments on account, on a discounted basis, but then demanded charges from their tenants on a weekly basis. It's no different. So clause 4.6 provides the customer shall send the provider an invoice, the VAT invoice, in respect of any value-added tax that is payable in respect the Customs Commission referred to in clause 3.2. Now, this is a specific clause that the parties have chosen to include in this agreement. And on its natural reading, it is consistent, we say, with a recognition that the Customs Commission is referable to some form of chargeable service for the benefit of the appellant, for which VAT is therefore payable. Because if it's not, and if it's correct to characterise the Commission as a pure discount, well, VAT would not be payable, and it is very hard to consider that these parties would have thought that it might be. So clause 4.6 does present a difficulty, and it assists us when we go back in time. But because we do not know from the four corners of the agreement what the Commission is for, one can only go so far with this. It just looks an oddity, and as my Lord knows, that Mr. Justice Morgan construed any as, for example, it may be in the future that any is payable. And yes, that is a potential interpretation. But we would say that when one goes back in time and sees that the Customer Commission is referable to the costs of collection plus bad debt provision, then any makes complete sense. Because the VAT will be payable on the collection services, it would not be payable on the element referable to bad debt. And that therefore explains why the word any is there. And if we're right on the past, then that makes far more sense.
And how do you work out which bit is commission and which bit is bad debt?
Well, I think the position under VAT law is that you have to say, well, what is properly referable to it?
So you'd have to do some sort of an apportionment.
I think that's right, a judgment.
Does that vary from year to year according to what the bad debt situation was in any given year?
My Lord, I imagine it would. I think that's the general point under VAT law, that if someone supplies both a service which attracts VAT and other things which do not attract it, one has to make an apportionment. My Lord, clause...
I suppose actually, I say year by year, but I suppose it would be month by month between April and November. With each commission on your argument, or each reduction in the amount payable by Kingston to TWU would be a separate supply.
That is right. Yes, yes.
So there would have to be some sort of monthly apportionment to reflect discount for bad debt on the one hand and provision of the supply on the other. So the net commission on your argument, which Kingston receives, would vary from month to month according to whether they themselves manage to collect from their tenants.
My Lord, yes, I think that logically would follow, yes. And clause 5 provides an information clause, and in a sense what it does is it recognises that clause 3.1 has dealt with short voids of less than 3 months, and clause 5 is dealing with longer term voids and indeed additions to the stock or disposals. And so that's providing for the appellant must provide information to Thames Water so it can work out what changes there are. Clearly, if there are sales from the stock, nothing is payable, monies are repayable. If there are additions, then they will also attract a water charge. Then clause 6 provides for end of year reconciliation. And then...
Can I just ask about clause 5?
Yes.
What happens to this monthly list? I couldn't see any consequence flowing from it.
I don't... Well, I think that...
They talk about a significant stock movement, but that's something different.
Yes, but I think that what happens to it is that all of the information provided under clause 5 is then taken into account under clause 6.1 in the end of year reconciliation. So the provider will use all the information, and that's what's given under clause 5. And so what it's doing is recognising that during the course of the year, Because of course the water charge, as I said at the beginning of the year, that's when all the financial obligations kick in. Then during the course of the year, properties will be void for a long period. You may acquire stock, you may sell stock, and that will impact upon what charges are payable, who is liable. Therefore, that information must be provided to the provider, and by the 15th of, anything given to it by the 15th of December, it will use in working out the end of year reconciliation for that year. And when it's provided later, I think there has to be a later reconciliation. And then one sees under clause 7, it's an agreement for 5 years from the 1st of April 2002. And then finally,
yes, I'm sorry. Could we just come back to Lord Justice Lewison's question? Because I'm still puzzled about this. I quite take your point that the information capitalise a defined term in clause 5, and it includes the monthly list of long-term voids.
yes,
But even so, and therefore, we know from clause 6.1 that that's to be used to generate an end-of-year reconciliation, or part of the information is to be used for that purpose.
yes.
But accepting all of that, where does that take you to? What is the significance of the monthly list of long-term voids when you do the reconciliation?
My lord, I think the significance is that if there are long-term voids for more than three calendar months or more, they will not be caught by the 3.5% reduction 3.1.
Why not?
Because 3.1 is premises likely to be unoccupied for a period of less than 3 months. That's what that's referable to.
But 3.1 says likely, so it's probabilistic. It's not based on actuality.
No, I know, but I think that it's allowed saying, well, my lord is absolutely right. The use of the word likely is absolutely correct. I think that what the parties were seeking to do is, well, if there are ordinary changes of tenancy, which we would imagine are going to be less than 3 months, then this agreement provides there'll be a 3.5% reduction. And that gets calculated at the beginning of the year and the payments are made. If, however, there are properties that are in fact unoccupied for periods of 3 months or more, then they will be dealt with in a different way, and that will be dealt with by means of provision of information and then reconciliation. Because if they're not to be dealt with by way of reconciliation and money paid back, then there is no purpose to this.
It might be said, both for this reason and some of the other reasons that you have touched on already, that all in all, this is a rather badly drafted agreement.
Yes. Yes. Yes.
So where does that take us to in terms of interpretation?
Well, the poorer the terms, the express terms of the agreement, the more receptive, I would submit, the court is to look at contextual and background matters to work out if what the parties actually meant by what they wrote down.
Thank you.
Well, then, in terms of the clause 7, that provides for duration. As I noted, it provides for a 5-year duration from 1st of April 2002. And then clause 7.3 provides that if the agreement is terminated under clause 7.2, then the customer will send the provider a list of all the unmetered premises together with the occupiers' names. So recognising that thereafter the that Thames Water would need the names in order directly to demand charges of them. So those are the express terms of the agreement. Say, I don't propose to go to the other clauses. It's right, there's an entire agreement clause under clause 9. In the court below, it was submitted that precluded the court from looking at prior agreements. That submission is not maintained here.
Clause 9.1 may be of some significance in looking at the previous arrangements, because that seems to say quite clearly that this agreement supersedes them.
Yes, well, we recognise it. It does supersede them, but it doesn't follow that it supersedes them by changing critical terms within them. So those are the express terms. I have to accept, of course, that what one doesn't see within this agreement are express terms reflective of agency.
I mean, however you look at it, all the points that you've made, that is a pretty extraordinary matter if the real effect was agency. I mean, to have an agreement written up in this way and not a single reference to the capacity, legal capacity, in which, as you would say, Kingston was acting on behalf of Thames Water. I mean, on any foot is remarkable. I mean, that isn't just poor drafting. That is extraordinary.
My lord, I have to accept, I have to accept that the terms of the agreement are not helpful to me. But I do say that, but because of the reference to custom commission allied to the VAT provision, which are not explained on the face of the agreement, particularly the VAT provision, then one does need to see, well, is there anything admissible from which one could work out what that was getting at? Now, if one can't, well, we lose. But if one can, we submit one must.
Well, I know, but it's all quite, if I may say so, despite your eloquence. The VAT point is all total speculation. I mean, it may have been put in there purely as a matter of caution, because although the parties had quite a clear idea of how the commission was to be treated in terms of the overall financial arrangements, somebody in the tax authorities may try to put up some sort of different case. I mean, it could be said with just as much credibility as any other explanation. It's put in there as a matter of caution, and that's what the judge found.
Well, of course, that is a possible conclusion. I accept that. I have to accept that. The question is it the correct conclusion? And that depends upon whether one should have regard to what went before, and can one draw anything of use from it.
Yes.
I'm afraid.
Yeah, no, I understand.
Is this a standard form of agreement?
My lord, there appear to have been, I think that there were, before the judge, I think some 18 agreements with Thames Water and various London local authorities. They're all in similar form, all dating from about 2000 to 2006. And there aren't many differences. We've included one in the bundle. That's the one from Camden.
Yes, well, that's what that recites.
That's
the
identical,
yeah.
but it has the recital about the
You also
1991
included
pact.
one from Southwark, which appears to be in exactly the same form.
I think Southwark doesn't have an entire agreement clause, but apart from that, yeah, that's right.
I mean, the reason I ask is that when one's dealing with a standard form, background plays a much smaller
Oh, yes.
part.
But this is not a standard form in those terms.
In that sense, right.
Yeah, but and it appears to be used a number of times, and it'd be nice to have found the draftsperson when they were doing it.
Yeah.
My lord, in terms of the statutory provisions, I'm very mindful of what my lord has said about the court being aware of them. So perhaps I can deal with it in shortened form and only take you to provisions if I need to. Would that be of assistance?
Yes, certainly.
My lord, what we would say that the water legislation from prior to the 1970s agreement onwards shares three common features of relevance. Firstly, the empowering of the making of annual charges schemes by the water authority, then the undertaker. Secondly, the fixing of primary liability for those charges upon certain persons, but also empowering the authority stroke undertaker to enter into an agreement with any other person who wishes to assume liability. And thirdly, has conferred express powers on local authorities to enter into agreements with water authorities, then undertakers, for the collection and recovery of charges on their behalf. And my Lord, just in a very brief form, prior to the Water Act 1973, just for my Lord's information, sewerage services were undertaken by the appellant itself under the Public Health Act, and the cost of those was, as my Lord knows, recovered in the general rate. Within Kingston's area, water was supplied by the Metropolitan Water Board, and there is no direct evidence as to how water charges, what water arrangements there were then, but it was a common feature of the water legislation before 1974 that the rating authorities were statutorily empowered to collect water charges owed to statutory water undertakers such as the MWB. And we provided a couple of old tenancy agreements in the supplementary bundle to show that prior to 1973, Kingston, as did very many housing authorities, collected both water rates and general rates, along with the tenant's rent. The Water Act, as my Lord knows, established 10 water authorities, including Thames Water Authority, and it provided a power to charge. I'll try to just give my Lord the section references generally, rather than
Yes,
my Lord.
just so that I know whether this is correct or not, I think you set a lot of this out in your appellant skeleton.
Well, I think we do set, yeah, we do set some of it out, yes. And equally,
All right, just so that I know.
yes.
Thanks.
So section 30, now I won't take you down these. Section 30 contained the power to charge, and that provided two alternatives. Firstly was a charges scheme, and secondly was agreement with any person. And then section 31 brought in the idea of the charges scheme. Section 34 applied to section 254 of the Local Government Act 1972. And what it did in Schedule 6, and that's page 13 of the Authorities Bundle, I won't take you to it, was that it empowered the Secretary of State to make orders under the 1972 Local Government Act, the effect of which was to require local authorities to collect and recover charges on behalf of the new water authorities in the transitional period, because of course it was all change. And indeed, in his judgment, the judge noted, it's paragraph 39, Roman 1, that a series of annual water authority collection of charges orders were made. So the effect of those orders very early on was to require an authority to collect and recover charges on behalf of the water authority when that authority gave notice. And that did happen in relation to Kingston and Thames Water. If I may then take my Lord to one of the statutes, that's the Local Government Act 1974, and it's in the Authorities Bundle at tab 4. And that is the section which expressly provided for a power to enter into agreements to collect and recover.
Sorry, can you give me the reference again?
It's Authorities Bundle tab 4, and it's page 16, my Lord.
Thank you.
And section 38 inserted a new section 32 into the 1973 Act, subsection 1 providing a local authority and a water authority may enter into an agreement for the collection and recovery by the local authority on behalf of the water authority of any charges payable for services performed, facilities provided, or rights made available in the local authority's area by the authority. So one had two public bodies here, and section 32 providing the virees for each of them to make an agreement specified in those terms. And this was the provision that was in force when the 1978 agreement with Thames Water was entered into. But that's all I take from that.
Yep.
Now, it just interposes in terms of the basis for the individual charge. Since April 1978, there has been a combined charge, which I'm sure my Lord knows, payable for unmetered domestic premises. Those charges are set out in annual charges schemes that have been required to be provided since the 1970s. And the charge per property is made up of 4 elements, 2 of them fixed and 2 based upon individual properties' rateable value. So there is a fixed annual charge for water services, with all properties in the same local authority area paying the same. There is similarly a fixed charge for wastewater services, and then there is a charge for water based upon a pence in the pound to be multiplied by the individual property's rateable value, and a similar provision for wastewater. There are 4 elements of the charge, 2 fixed and 2 variable. And just for my Lord's notes, these bases of charge are set out in the annual charges scheme. For 2002 to 3, the reference is Authorities Bundles, tab 13, page 130, in relation to the 2 water charges, and page 154 for the wastewater charges. What we don't have in the bundle is the actual figures provided for that year. I'm afraid that wasn't available, but generally just takes the form of a fixed charge and then a rate. So if one then moves on, in 1989 the water industry was privatised and Thames Water Authority ceased to exist and was replaced by Thames Water Utilities Ltd. And the new Act restated the powers and duties of the new water undertakers. And although this was the legislation in place when Thames Water Utilities came into existence, and therefore the agreement with the appellant continued, it was of course replaced by the consolidated legislation in 1991, and therefore I don't propose to waste the court's time in taking you to lots of these provisions, then to take them again. Save for one provision I should take you to, which concerns the collection on behalf power. Now take you therefore to Authorities Bundle, tab 7, page 31. And this is within Schedule 25, minor and consequential amendments. And paragraph 40 provides the powers conferred by Section 1 of the Local Authorities Goods and Services Act shall be exercisable by the authority, that means the National Rivers Authority, and then 5 lines down says, and the powers of a local authority under that Act shall be deemed to include power to enter in an agreement for the collection and recovery by the authority on behalf of any water undertaker or sewerage undertaker of any charges fixed by the undertaker under Chapter 4 of Part 2 of the Water Act 1989. Obviously, because Thames Water Authority no longer existed, and therefore one wasn't dealing with a public body but a company regulated by the 1989 Act, there was no need to deal with any virus provision here for Thames Water Utilities. And this is the replacement power found. And it was done by deeming the powers in Section 1 to include this power. My Lord, we have Section 1, I don't take you to it, it's the Authorities Bundle, tab 1, page 1.
And this was repeated in the Consequential Provisions Act.
My Lord, it was, that's correct, yes. Then one goes to the 1991 Act, which was a consolidating act passed upon recommendation of the Royal Commission to law relating to water and sewerage charges, and it consolidated with amendments the Water Act 1989 provisions, and the particular provisions that we're concerned with, that is the powers to charge, which were found in Chapter 4 of Part 2 of the 1989 Act, are now found in Chapter 1 to Part 5, sorry, other way round. The powers that were in Chapter 1 to Part 5 of the 89 Act are now in Chapter... No, my notes are completely wrong. I'll just stop that sentence there and just take you, my lord, the provisions rather than messing around. It's page 77 of tab 8. And we're in Chapter 1 of Part 5 of the Act, which replaced the previous provisions. And Section 142 is the power to charge. And it provides, subject to following provisions of this chapter, the powers of every relevant undertaker shall include power, A, to fix charges and any services provided in the course of carrying out its functions, B, to demand and recover charges fixed under this section from any persons to whom the undertaker provides services, or in relation to whom it carries out effluent functions, and then, subject to subsections 2A, 3 and 3A, the powers conferred by subsection 1 above shall be exercisable by or in accordance with the charges scheme under section 143 below, or by or in accordance with agreements with the persons to be charged. And then subsection 2A provides, that was added by the Water Industry Act 1999, paragraph B of subsection 2 above shall not have effect in relation to A, charges for the supply of water to a dwelling, or B, charges for the provision of sewerage service in respect of a dwelling. And what we say about section 142 is that it confers two powers to charge. The first is in accordance with the charges scheme under section 143.
You made the point a moment ago that, of course, post-privatisation, we're dealing with private companies and not with statutory authorities.
Yes.
Why, therefore, do these powers need to be conferred on them? Why don't private companies have the power to charge for their services anyway?
Well, because the point is because they are regulated. Their power charge is regulated.
Well, one can understand the need for regulation and the provision of regulation, but that's not what this is doing. This is not regulating, it's empowering.
Well, yeah, it's empowering, but subsection 2A provides it's to be in accordance with the charges scheme. So it empowers them to make charges, but they are to be in accordance with the charges scheme. That is made under section 143, and it needs to be approved by the then Director General for Ofwat. And one sees that from section 143, subsection 6 on page 80. A charges scheme shall not take effect unless it's been approved by the Director. Obviously, what Parliament was concerned with was to ensure that when the water industry was privatised, and there had been charges scheme in the past undertaken by public bodies, the new corporate entities couldn't simply charge what they wanted. They still had to be charging in accordance with schemes which were approved by an independent body. So
anyway, you were saying two powers to charge under the charter scheme, and 2B.
Or by in accordance with agreements by the person charged.
Yeah, exactly.
And that preserves the ability that was found under section 30 of the 1973 Act to enter into an agreement with a person to be charged.
All right.
Then, one matter we should note is the subsection 2 capital A, because that has reference to 2B, agreements for the person to be charged. And that provides that paragraph B shall not have effect in relation to charges for the supply of water to a dwelling or charges for the provision of sewerage service in respect of a dwelling. And what we consider this means is that although it is open to an undertaker to enter into an agreement with a person, see subsection 2, small b, when that is concerned with charges for supply of water to a dwelling or sewerage charges to a dwelling, the charges themselves can't be whatever the undertaker wishes to charge. They are still subject to the charges scheme. And so that would explain, in the instant case, why the 2003 agreement was based upon all of the charges for the individual premises added up together in accordance with the charges scheme.
That's on the basis that the singular includes the plural.
Yes, I think the judge was uncertain about that. But I mean, we have never submitted that there was no power. The company anyway, there's no power to make this as an agreement if the judge was right. We accept there would have been power. My Lord, then page 79 is section 143. That is the power to make the charges scheme. As already indicated, that has to be approved by the director. And then section 144 on page 84, that provides for the person who is to be charged. So, as my Lord notes, section 142 refers to persons to whom the undertaker provides services. And so when one comes to 1441, which is liability of occupiers, subject to the following provisions of this section, and except insofar as provisions to the contrary is made by any agreement to which the undertaker is a party. That's how the judge classified this agreement. Supplies of water provided by a water undertaker shall be treated for the purpose of this chapter as services provided to the occupiers for the time being a premises supplied, and similarly so for sewerage charges. So the default position under the Act is that the person liable for the charges is the occupier. They are the ones who have the statutory liability. They are required to pay the charges. These are charges that must be calculated in accordance with the charges scheme. But that is subject, of course, to agreements to the contrary. And then the final section from this Act I'd like to take my Lord to is section 150 at page 99. And this is the power to fix maximum charges. And this replaced section 82 in the 1989 Act. And it provides the director may from time to time by order fix maximum charges which a person who is not a relevant undertaker may recover from another such a person in respect of water supplies or sewerage services provided to that other person with the help of services provided by a relevant undertaker. And under subsection 3 it provides it shall be the duty of the director to publish any order under the section in such manner as he considers appropriate for the purpose of bringing it to the attention of persons likely to be affected by it. So this is the power under which the director was empowered to make the water resale orders. And although subsection 1 has a rather convoluted turn of phrase in terms of when it applies, and the water resale orders, as we know, just talk about purchaser and reseller, we do not contend that if the judge was correct in his interpretation of the agreement, we would not fit within section 150 and then the resale orders. And so I think that's and I think that we do that later. So that is the 1991 Act. And as my Lord Justice Lewison has already indicated, the power to enter into an agreement with the collection and recovery of charges under this part was reenacted in the Consequential Provisions Act. I don't take you to that. The reference is Authorities Bundle, tab 10, paragraph, page 116, and it's paragraph 20 to Schedule 1. And it's enacted in the identical form. And because this is a scheme of legislation, it's consolidated legislation, one would read that Act pari materia along with the 1991 Act. And so that primary legislation that we've looked at contemplates two forms of agreement made by an undertaker in relation to charges. Firstly, an agreement under section 144 that may be with anyone, and that person thereby accepts a primary liability for charges. And secondly, or alternatively, an agreement with a local authority for the collection and recovery on behalf of the undertaker of its charges fixed under that part of the Act. And necessarily we say those two forms of agreement are logically distinct. Can I now go to the Water Resale Order for 2001? It's tab 11. And it was made in February 2001, came to operation on the 1st of April. And as I say, rather than the terms in section 150, it used the terms purchaser and reseller. And one sees, footer page 117, reseller means any person who is not a relevant undertaker, but who A, provides any purchaser a supply of piped water, which a water undertaker has supplied directly or indirectly to the reseller, or provides to any purchaser a sewerage service. And we agree that if we are caught with 144, we are within this. Can I note a couple of points about the order, if I may? The first is that when one looks at definitions and dwellings, and it refers to four different paragraphs: a private dwelling house, a caravan within the meaning of the 1960 Act, a boat or similar structure, or any house in multiple occupation as defined by section 341 to the Housing Act 1985. And I simply make these points now because it is part of our case that the Water Resale Order would have been reasonably available to the appellant when it came to make the agreement. And we would note that the appellant is the local housing authority under the 1985 Act. And one sees that's referred to in subpara D. And indeed, it has the regulatory and statutory functions in relation to houses in multiple occupation, which is referred to there. And in addition, it was the licensing authority for caravan sites under Part 1 of the 1960 Act. So if one is thinking about, well, is this the kind of document that would come to the attention of this particular party to an agreement, we would say it is. It would be entirely different, perhaps, if there's an agreement made with the water undertaker and a completely private person who had no interest.
So can I just understand D?
Yes.
This is a house in multiple occupation, which does not constitute a dwelling. What is that contemplating?
I think that is contemplating a house occupied by a number of individuals in bedsits or individual rooms sharing facilities. But that wouldn't be a private dwelling house within A, which is contemplating more sort of someone in exclusive occupation.
What does section 345 of the Housing Act 1985 say?
Well, that will provide that provides a definition of a house in multiple occupation, or it did at the time. It's now been replaced. Again, it's quite a complicated definition. The point is that the Water Resale Order was getting at cases where water was supplied, say, to a property where you had 10 people living there in a bedroom. There was no water meter. They didn't have an individual supply. The owner agreed to be liable for the charge. And in those circumstances, the owner is a reseller, and the terms of the order apply to regulate what they can recover. And indeed, in Thames Water's charges scheme, it refers to what are called common billing arrangements, which is very much that, where you have a block or a house, which either has 1 meter only or no meter, but the landlord agrees, section 144, to be liable for the charges, but then is regulated by the terms of this order. And so the reference to caravans, in the guidance to the Water Resale Order, which we don't have in the bundles, in Ofwat's guidance, the worked examples for the order concerned where you had mobile home sites. We have a number of mobile homes on a site. There is 1 pipe to the curtilage, 1 meter, and then distribution through by the owner.
All right.
The owner agrees, and so that's really what it's getting at. But I accept that it's
No,
not
I
exclusively
understand it.
getting
I understand it now. I'm looking at it. Yeah.
So those definitions. Then, in terms of maximum charges, these are dealt with in paragraph 5 of the order. And we are concerned with 5.2, because 5.1 is dealing with metered cases. And 5.2a deals with the undertaker's average bill for an unmeasured water supply. We needn't worry about that, because that's subject to B. Without prejudice to Part A of this paragraph, if a purchaser's water supply is unmeasured, the maximum charge must be calculated as follows. First, any amounts recoverable either under subparagraph 1 above or from any other person supplied must be deducted from the amount payable by the reseller to the relevant undertaker. Those words obviously were highlighted by the judge in determining that the commission and the voids allowance be deducted. After which, the amount still to be recovered may then be either shared, 1, equally between the purchasers to whom this subparagraph applies, or 2, in proportion to the respective rateable values, square footages, occupancy, or number of bedrooms in each of the affected purchasers' dwellings. And the point we make about this is that, as my lords know, under the charges scheme, the charge is made up of the 4 elements, 2 fixed, 2 based upon rateable value, and where the undertaker demands direct, which is the default, it must demand those charges. It has no discretion, and the individual knows. Whereas under this order, once one works out what is the amount payable by the reseller to the relevant undertaker, a different formula applies, which is a matter for the reseller to determine, and is either equal sharing, or rateable values, or the other bases. And so one can readily see that this is a different formula to that which would have pertained without an agreement, and could have very significant ramifications. In this case, the rateable values of the various properties, and the judge had evidence of this, ranged from 115 to 376, based upon the 1990 valuation. So a considerable difference. And so for 2007 to 8, which is the earliest bill we had, someone with a rateable value of £115 would have paid £161 for their water, based upon the charges scheme, whereas someone with a rateable value of 376 would have paid £397, charges scheme. If the agreement between my client and Thames Water is one that is caught by that, then those bases of calculation go out the window, and one is left solely with the formulae in paragraph 5.2. And we will say that it's very unlikely that Thames Water Utilities and Kingston Borough Council, assuming this is part of the admissible background, would have made an agreement under which Kingston was bound then to charge individuals, not based upon the charges scheme that they've been doing since 1978, but on a completely different basis, without any knowledge to them.
Sorry,
without them knowing. I mean, they had no ability to change that arrangement. We said that would have been very surprising, because it could have had great unfairness to many thousands of tenants.
But there was no disclosure, was there, by the local authority of anything suggesting that they drew their attention to this?
To the
issues you're talking about.
My lord, no, there's not. There's not. I mean, I can only rely upon the order in terms
The inference from that would tend to be that they didn't. If they simply, unless a lot, I mean, it may be that all the documents have been destroyed, but it sounds as though that's not the case, because you produced a massive documentation illustrating the historical development of the arrangements. But there's nothing, am I right, that was disclosed relating to the Water Resale Order and its implications.
My lord, can I answer both points? Firstly, we would have loved to produce masses of documentation. We haven't. We managed to produce about a dozen committee resolutions and letters after a huge amount of effort, which was referred to in witness evidence before the judge. The picture is anything but complete. But secondly, my lord is absolutely right. There is no reference to the Water Resale Order at all, which is why I have to put my submissions in relation to that. as if that was something which was reasonably available to the parties when making the agreement, which I'll come to in due course. If you hold that it wasn't reasonably available, and therefore is not an aid to interpretation, then it is just a very odd consequence that flows from the agreement that was made.
Well, it's not really a question for you, I appreciate, but is it suggested that it was not reasonably available?
I think it is, yes.
I see.
It
Thank
is.
you.
Then the final matter to note about the 2001 order is paragraph 7, which provides for the addition of an administration charge. And one sees it is an administration charge for the reseller's cost of billing, paragraph 7.1. So that's all it is. And in an unmetered case, that's 1.5 pence a day, and that amounts to £5.48 per annum. So it's common ground that if Kingston was a water reseller, it could add that onto every bill, but it was still, on any basis, a very bad deal for it, because if we're wrong, because for 2001 to 2, the agreed commission was £81,500. The voids allowance was £31,500. That's supplementary bundle page 69. If all of that had to be paid back, all it could recover was £25,500 under paragraph 7, so very much out of pocket. But, you know, either interpretation or tough. Well, the 2001 order was then replaced by a 2006 order. That's in the papers. I don't take you to it because, of course, it can't affect interpretation.
The definitions are the same anyway.
What you say that the means of the formula for dividing is slightly more sophisticated, but it still doesn't enable one to simply say, charter scheme says this, that's what you're going to pay. This is a bit more sophisticated. Well, that's one to say about the statutory provisions. May I take you then to the two cases where the collection on behalf of power was considered?
Yeah, just before we get to those two cases, can you help me as to the relevance of those two cases? Because my present understanding is that the issue that confronted the court in those cases was one of virings. So it's a public law issue.
Yeah.
It's not concerned with the effect of the agreements as a matter of private law.
Well, 2 points. The reason for going to I accept that, my lord. The reason for going to Thomas is because we say that the court was there considering an agreement which was materially the same as the pre-2003 agreement, and heard argument and concluded that it was a contracted agency, and in the course of doing that noted that there was an accounting provision, albeit it was a very basic one. And we would say that in our case, firstly, the pre-2000 agreement was on all fours with that in Thomas, and the 2000 agreement does have a very basic accounting provision. Once one understands what commission is for, the accounting provision is lump sum and discounted, as it was in Thomas. And so far as Jones is concerned, go to that for the point, 2 points. Firstly, again, the very basic nature of the accounting provision there, because under that agreement, Rochdale paid everything, but then there's a lock-off.
Said Jones. Rochdale and Dixon.
Yes, Dixon, yes, sorry. In Dixon, there was a similar discounted basis under which the authorities' charges were calculated. And also, I do go to Dixon because whilst I accept it was a case about vires, what we say about it is that it was contemplating that an agreement could be made under this statutory provision, which was not an agreement which necessarily had to have an established private law nature, namely agency or assignment. I accept that what Lord Justice Ricks there is obiter. I accept equally, my friend says, it's all about vires, it's irrelevant. But that is the basis for our argument that an agreement for collection and recovery on behalf of is, or may be, a sui generis form of agreement, which doesn't require all the requirements of agency. Of course, we make that submission because we accept that the terms of the agreement are not overly helpful to an agency agreement. So that's why I go there, but I, of course, recognise what my Lord has said. May I then go first to Thomas. which is at tab 15. And this was a case where there were arrears of the authority was collecting water rates along with the rent. It then sought possession, and the judge required proof of its entitlement to collect those water rates. And Lambeth appeared by Queen's Counsel and satisfied the court. He then, however, the judge refused to make an order for possession, and therefore the matter came to the Court of Appeal in the context of Lambeth's appeal against that refusal. Now, it is right to note that the tenant was unrepresented and there was no cross-appeal. However, the court of its own motion asked for argument on whether water charges could properly be regarded as rent or other obligations. One takes that from Mr. Justice Mance, as he then was his judgment, at page 204, midway down. And what we say is it is clear that the court was in that case concerned about the nature of the agreement between Thames Water and Lambeth, by virtue of which it could then argue that the water charges were payable to the tenant as an obligation of its tenancy. And indeed, that was a question we would submit, a logically prior question, which it had to answer. Added to that, Lord Justice Dixon was in no doubt that Mr. Justice Mance gave close and detailed consideration to whether this was within the statutory language that was violated. So the at 206, where the sideline, the judge, after hearing evidence, was satisfied that counsel entered into an agreement. He described the origin of the agreement as lost in the mists of time, but set out certain of its characteristics which are worth mention. The council, consistent with the statutory language, claims and seeks to collect from its tenants the amounts fixed by the water company in respect of their particular properties. When it comes to accounting the water company, the council does so on a lump sum and discounted basis, we were told, twice yearly. The discounted lump sum is arrived at by negotiation and is based on the total water charges for all relevant council properties, less a discount to take account of unoccupied premises and cost of collection. Presumably, although it isn't stated, the discount also takes account the risks of non-recovery, since it appears the council undertakes to pay the water company discounted lump sum irrespective of what it recovers from tenants. We're told that, and it talks about the housing revenue account, and then 6 lines below the bottom of this first paragraph, it is always open to an agent to contract on such a basis, and I see no objection in the present statutory context to the arrangement made between the council and the water company. He notes that any surplus then goes into the housing revenue account. So we say that Thomas, for all the caveats I made about it being individual person, etc., is nonetheless authority that this form of agreement between Lambeth and Thames Water was an agency relationship which was within the statutory powers. We will say that is materially the same to the agreement between my client and Thames Water before 2003.
It didn't matter though in Thomas, did it?
Well,
Mrs. Thomas had an obligation to pay the amount of rent and other charges on the card, and that included rent and other charges payable which could be altered other than the level of water and sewerage charges, see clause 8.2. So clearly the contemplation was that she had to pay water and sewerage charges, and the only question was, if she didn't, was that a breach of the terms of her tenancy? Well, obviously it was.
yes, but the court still had to be satisfied. I mean, it's one thing to say we must pay it, but if the authority, if Lambeth had no entitlement to make those charges, that would necessarily be relevant to whether that was an obligation that could be enforced. And that's why the court was obviously concerned, well, why is it? What basis can Lambeth be said to be charging these amounts from a tenant? Bearing in mind, of course, it was doing so in the context then of seeking possession of the property from unpaid.
I mean, it could have done it in the way that the judge found Kingston has done it, by agreeing with the water authority, statutory water authority in those days, because it's 1997, to pay the water charges and then recover from the tenant. So on the point that we're considering, it really doesn't help, does it?
Well, no, it does, because it still is looking at this agreement saying this is a contract of agency. That's what I take.
Well, what it's doing is it says it's always open to an agent to contract on such a basis.
Yes.
Well, who's denying that?
You're saying it's always open and, well...
I mean, that's all he says.
But the point is that that is the same basis upon which Kingston was contracting before 2003, and indeed we would say after 2003, because once one understands what the commission is for, what it is doing, it is saying we are contracted as agent in that rather than taking a fee for the provision of our services worked on an hourly basis, we'll base it upon a commission and we'll account to you by paying you 8 monthly payments as opposed to Lambert.
Well, I understand all that, but why do we need Thomas to tell us that?
Well, my lord, it is one of the 2 authorities where this provision is being considered, and it was also referred to
Anyway.
in both Dixon and...
All right, we've got the point.
My lord, then, so far as Dixon is concerned, that is at tab 19. And that was factually different, because the agreement there was entered into 2005. It was a far more sophisticated agreement in terms of agency, and I can't say any of that. I also accept that what Lord Justice Rick said about the acting on behalf of was obiter. Can I take you to paragraph 38? And I accept it was about Vary, so I accept that. So paragraph 38 is setting out the arguments for Mr. Dixon. And the first of the agreement was not one for collection and recovery of charges, because Rochdale simply bought them for itself, paid for them in advance, and then recovered for itself its outlay throughout the year. They may have been called water charges, but they were owed it not to you. And then second, in any event, they were not collected and recovered on behalf of it. No element of agency involved. Mr. Westgate
Sorry,
emphasised...
could you just give me the paragraph number?
My lord, it's 38 on page 3.
Oh, yes, I've got it, thanks. Thank you.
And then over the page on page 312, the third was that the water charges collected had not been fixed or demanded by ULL but by Rochdale. There are perhaps different ways of saying the same thing, which was in essence that you had dropped completely out of the picture. At any rate, wants to be paid by Rochdale, and all that was left was a bipartite agreement between Rochdale and its tenants. Then those submissions were said by Lord Justice Rich to miss the mark. And,
But that's because of the terms of the agreement. And if you go back to paragraph 13, page 304, you've got a recitation of the power to enter into the agreement on behalf of the company. Recital D is that there is an agreement.
Yep.
The council will collect charges on behalf of the company. Consideration on clause 2.1 on the next page, paragraph 15,
yep,
is the council agrees to provide the services.
yes,
Then there's an authority from the company to the council to collect the charges. Then there's an obligation to use reasonable skill and care to collect and recover the charges, and so on and so forth.
yes.
So it's a very different agreement.
It is a very different agreement. I accept that.
But I mean, as a general proposition, a decision by a court on one form of contract is really of no help in the interpretation of a different.
And I'm not suggesting otherwise. Of course not. I mean, and it wouldn't offer much help to me anyway.
Yes, probably wouldn't.
But the real point about Dixon is in paragraphs 49 to 50. And this is getting it.
49 to 50.
Yes, please. Where Lord Justice Ricks says at the foot of page 315, if having looked at Thomas, if however I'm wrong about this, and the concept of agency is inappropriately invoked in the analysis of these arrangements, there's also authority. The expression on behalf of doesn't necessarily require the concept of agency, but may have the more general meaning of for the benefit or other phrases. And he then cites Sir Thane Forbes in the case of S, and then at 50 says, these conclusions seem correct to me. Indeed, I'd include the simple proposition for as one of the possible meanings. In the circumstances, many of these meanings could apply here so as to undermine Mr. Westgate's ultra vires argument. Thus, even if perchance the ultimately correct analysis of the agreement were to be found not in agency, but for instance in the concept of assignment, if indeed the statutory claims of undertakers can be assigned, it would seem to me the arrangement still amounted to a collection and recovery of water charges on behalf of the water undertaker. Now, I accept that this passage is obiter, but the point we seek to draw from it is that Lord Justice Rix's analysis of the power is, we would say, inconsistent with his considering that the only way in which the power was capable of being exercised was by the entry of the local authority into an agreement of agency or of assignment. Because had that been his view, and that paragraph 20 permits only of agency and perchance, if available, assignment, then he wouldn't have engaged in the other potential meanings of on behalf of. And we say that what he was recognising is that this power permits an agreement sui generis for collection and recovery on behalf of the undertaker, but which does not amount to formal agency or assignment. That is as high as I can take that point, but I do preannate the fact that when one looks at the original provision in the 1974 Act, albeit I accept between two public bodies, it was empowering them to enter into an agreement for the collection and recovery on charges. Nothing to say that had to be purely agency or assignment, and that formulation has been maintained in the legislation post-privatisation, and there's no suggestion that Thames Water Utilities Ltd couldn't have entered into some form of sui generis agreement.
But if you go back to paragraph 49,
yes,
one of the possible meanings of on behalf of means instead of.
Yes.
If Kingston is collecting the water charges instead of TWU, that doesn't preclude it from being a water reseller, does it? Instead of TWU collecting the charges, Kingston's going to. And that's because it's bought the water, the service from Kingston, and is reselling it to its tenants.
Well, I would still say that would be, but our position has to be that if an agreement is made under this power, so if it is properly construed, an agreement for collection and recovery under this power, it is not an agreement under section 144 of the 1991 Act. And therefore, it is not possible for Kingston to be a water reseller. That has to be my argument. Well, that's what I want to say about the various statutory provisions and the case law. In terms of the evidence before the judge, if I may, I want to major, I think, probably just on the 1977 letter and then maybe a couple of later documents. And these are in the supplemental bundle. And the October 1977 letter is page 28. And one notes that it's 27th of October 1977, written to Kingston.
I beg your pardon, could you give me the page again?
My Lord, yes, it's page 28.
Thank you.
And in the first paragraph, it refers to a letter being sent from the authority's decision to proceed with the combined billing of the water supply and miscellaneous charges with effect from the 1st of April 1978. That's already explained to my Lord, that's what happened thereafter. It was also indicated that if your council wished to continue to collect water charges from tenants of council properties let on an inclusive basis, the Thames Water would be pleased to enter into an appropriate agency agreement.
So this is pre-contractual negotiations.
Well, we say that the proper inference to draw is that the agreement concluded by Thames Water and the appellant was the terms of this letter as accepted by a resolution of the Finance Committee, which had an actual percentage in for the voids provision. And We do not have any other.
So this is an offer, therefore, which was accepted.
Yes. Yes.
Such as to bring about a contract.
Yes, that is right. And I accept that the only material that we have is the letter, the resolution, and then later references to the letter by Kingston to Thames Water Utilities in the 1990s, where it's clear from that, and it's clear that there was no written agreement, and we say that the court can be satisfied on balance that the proper inference to be drawn is that this letter did form the basis for the agreement.
Did the judge find that this was an offer which was accepted?
He didn't deal with that, no. What he said was that he gave some statements as the arrangement, but then said that he didn't find anything to be gained from the prior 2003 arrangements because the arrangements weren't identical and because the statute provisions in place were different.
Right, next one.
And the point about the first paragraph is the contingent clause. So it's clear that they were already collecting. And of course, that would have been as a matter of obligation because of the pursuant to the transitional charging orders. Then one notes, second paragraph refers to a unified all-London approach. And towards the bottom of the page, then says, we approve to set out our formal proposition. So absolutely, it is their offer. And then the third one is the one we're concerned with, the collection of water charges from council tenants. And it says, in relation to collection from council tenants is necessary for administrative reasons, establish the position as quickly as possible. Necessarily so, because otherwise Tenants Water would have to deal with it itself. Collection from tenants is dealt with starting from the foot of that page at 30. And from the foot of page 30 to the top of page 31, it sets out the new combined charge that's going to be enforced from April 1978. As I say, that charge has remained in place throughout. The second main paragraph on the page refers to the proposals, but then says 5 lines from the bottom of the first substantive paragraph. Second paragraph, Thames Water's concern would be for the recovery of the total sum due for property, separate accounting by collecting agents for the constituent elements of the charge for individual properties would not be required or expected. So what it's doing is saying, well, there are going to be 4 new elements of the charge, and so far as we're concerned, we just want to know, that we are only concerned about accounting for the total sum due. We're not fussed in terms of constituent elements. The next paragraph refers to changes in the course of that year. And then, foot of page 31, having specified that Thames will be prepared to reimburse you, I'd now like to turn to the question of the separate commission payable for acting as collecting agents. Thames Water's view, as a reasonable objective, would be to leave all parties participating in broadly the same financial position as is at present. And we submit that the reference to the authority acting as collecting agents, that infers obligation, an obligation to collect. Not you may collect if you wish, but you will be collecting and you'll be required to collect. And one sees over onto page 32. I'm afraid the copying isn't very good, but in the first paragraph, 4 lines down, says it's been decided to suggest a uniform percentage to apply in all cases. Notwithstanding this, Thames is prepared to entertain claims now or at any time in the future for different treatment where a particular authority is able to show this will be supported by the facts. Any agreement will be subject to this option. So that's recognising that any percentage set in the agreement will be subject to later variation. Then, next paragraph, the Thames Water proposal is that in return for collecting its water charges from tenants of all premises let on the basis of an inclusive rental, the local authority concerned will be paid a collection commission at the rate of 2% of the total water charge raised. This 2% will be deemed to cover the administrative costs of collection and any losses through non-recovery. And then it should be noted this will also apply to the miscellaneous charge. Then missing a couple of lines, 4 lines at the bottom of this paragraph. It is suggested the payment of the whole amount of this authority should be made on the basis widely accepted for water supply at the present time, namely by the 15th of the 4th month of each half year. So we say here, this is offering a collecting agency agreement and an obligation to collect on these terms of a 2% commission deemed to cover both the cost of collection and also losses through non-recovery, and the payment to be made twice yearly as set out there. The letter then goes on to turn to void allowances, and they say that would be additional to this collection commission. These could be calculated on the basis of the actual empty period, or be the subject of a compounding percentage, as at present applies in many cases for water supply only. Just pausing there. The implication from that is that in terms of current arrangements, where the authorities are collecting water charges pursuant to the orders, there is already an allowance to reflect the fact that there will be voids from time to time, rather than working out actual amounts.
Which of these 2 alternatives was accepted?
The latter. It goes on, these last figures have been agreed at various times on the basis of actual experience. And then it says, technical reasons, present percentages may prove to be a little on the low side from the 1st of April, and it's suggested that existing figures should be increased by 0.25% and applied to the combined charge. Now, what we do not know from these documents is what the charge for Kingston was as at this time. But what we do know when we look at the resolution is that accepted a particular percentage. So we can know that whatever the percentage was now, the one that was agreed on is the one in the resolution. But I accept that this doesn't actually give a particular percentage to be accepted. And I accept, therefore, there will have to have been other correspondence between this letter and the resolution. I mean, that's self-evident.
Which page is the resolution?
My lord, that is on page 38. Come back to that, go straight to that. And that's the resolution of the Finance and General Purposes Subcommittee. The following arrangements, that's the same word used in the letter, the Thames Water be accepted, 2% collection commission, avoids an allowance of 1.75% of water rates. And whilst, of course, this is an internal document, it is self-evident that the resolution of the subcommittee would have been communicated to Thames Water, thereby giving rise to the agreement from the 1st of April 1978. Can I go back to the letter, if I may? And staying on page 32, having dealt with the compounding percentage, it then goes on some 8 lines down in the penultimate paragraph. The allowances would apply to permanent and acquired housing premises only, and would be intended to cover voids arising from normal changes of tenancy. Premises which are empty on acquisition, or which are vacated with a view to demolition, would be excluded. In these cases, the void allowance would be separately calculated and would be allowed instead of the compounding percentage. So one has here the early recognition that the voids allowance is for intra-tenancy voids, and other voids, for the reasons here stated, or doubtless other ones, will be dealt with in a different way once these residents were that in the 2003 agreement. And then one sees the last sentence of this paragraph. It's considered that the administrative advantages to both our authorities of such a compounding arrangement would be considerable. I.e. a big steer here from Thames Water, that whilst it is content to consider reductions based upon actual voids, it doesn't want to get into that, and he wants to agree a simple percentage.
The void allowance for empty properties or vacated with a view to demolition are to have a void allowance separately calculated.
Yes,
Is that right? Has that been accepted somewhere?
Yeah, well, yes, because there's been this thing called it's a thing called you're seeing in later correspondence there's a reference to allowances and brought forwards, because and equally before the 2003 agreement was entered into, we have one of the internal Kingston documents supplied to Thames Water, where it provided to Thames Water properties that had gone from its stock and those had been acquired from its stock, into its stock. So this was accepted, yes.
So the judge's findings are set out in paragraph 55 of his judgment.
Yeah.
Now, I'm a bit unclear as to why you're showing us these documents in circumstances where not only do we have a position where we have the judge's findings of fact as set out in paragraph 55, but also there's no ground of appeal challenging those findings of fact.
Well, there is a ground of appeal, but the judge was wrong not to have regard to the proper terms of the pre-2003 agreement in determining interpretation, and is implicit within that.
Then this sets out what they were.
But what the judge doesn't do is determine what the contractual provisions were, or then deal them in. He says they're different. He doesn't explain why. He doesn't actually reach any conclusions as to what the nature of the agreement was. Well, if the failure is one in terms of our grounds of appeal and not expressly challenging this finding of fact, then I admit to that. But it was intended to encompass the fact that once one admits that one can look at the pre-2003 agreement, one has to work out precisely what it did. And these are the submissions I'm now making, that it was an agreement by an agency for the collection of charges referable to two payments.
Right. Now, we're not going to go through a whole lot of letters, are we?
No. Well, we've already seen the resolution from that, and so we say that the court can be satisfied that the letter plus the resolution and communication form the basis for the agreement. If we're wrong on that, then again we're in trouble. But that's how we put it. Then, my lord, in terms of the later document, I will take you just two or three if I may. I'm not going to take you to many. The first is page 39, and this is a letter from Thames Water Utilities, some 2.5 months after it became the undertaker. One notes I'm writing to remind you of 2 points with regard to your water service charge account for council housing. And it talks about centralisation of accounts, close liaison with staff, and we still wish to ensure that. The second thing, I must inform you that unless specifically agreed, otherwise you should ensure we receive payment of 50% of your account on or before 15th of July and the balance by 15th of January. So this is a letter, it's a reminder referring to the same payment dates as set out in the 1977 letter, and it evidences quite clearly a simple continuum of the previous agreement with Thames Water by TWU. There's nothing to suggest there was a new agreement. This is all just business as usual. Then may I take you to page 45, which is a letter from Thames Water in 1993 to Kingston, and it states, on your adjustments for void and commission, I notice this has been deducted for the current year plus any brought forward amounts. Both adjustments are only deducted with the current year's bill, and brought forward adjustments have already had allowances made last year. And brought forward amounts are this very point about properties that had ceased to be within Kingston stock or long-term voids and acquired. And one sees that there are amounts, higher amounts due and owing to Kingston from page 46, which is Thames Water's own calculation. One can also see there that the then figures for 3.5% for voids and 9% for commission. Then you have the brought forwards. One credit, money due back. So again, it's the same process. Then I take you to page 47. This is a letter from Kingston, from Thames Water in August 1993, and it asks the Kingston to reaffirm the agreement we currently hold on a tear-off reply paid agreement, and it gives agreement 30th of April. That must refer to the letter of the 30th of April that we looked at, and then the payment dates.
Well, that's the letter at page 41, I think.
It is, yes. And then page 48 is a letter from Kingston in 1993, written by Mr. Bond, who was then to sign the 2003 agreement. And the context here was that it appeared that he was taking the view that the 9% commission should be payable on the whole amount before one took off the voids, and Thames Water saying otherwise. And in this paragraph, he quotes directly from the October 77 letter. So clearly, Kingston had a copy of that letter. And indeed, it refers to it, or rather, he sends it to Thames Water later in the course of the concept, which I don't take you to, and says the second time I've sent it to you. Then page 50 is another letter from him, which is still on the same point, second para. As you know, following the 1977 agreement between this authority and Thames Water, always been accepted practice of combining the voids allowance of 3.5% with the commission allowance of 9%, creating an overall figure of 12.5%. And at the foot of the page, he talks about tenants wanting refunds in relation to certain properties.
But rather curiously, on the previous page, page 49, Thames Water Utilities say they have no record of the agreement.
That's right, they do. And they ask him to supply a copy of it, and in due course, he does. See, one thing they don't say, they don't say, by the way, an agreement with April 78 has nothing to do with us because we're, a statutory, we're a company. This was with the older Water Authority.
Well, what exactly is the process you're taking us through now?
Well, I'm seeking to show that the terms of the agreement prior to 2003 were materially the same as that which one then finds in the 2003 agreement, by reference to the payment dates and the void and the commission percentages. But I can take you, I think, purely simply to one final document, if I may, and that is the one at page 68. This is headed Water Service Charges 2001 to 2002. And before the judge, there was evidence that the appellant periodically notified Thames Water of changes in its housing stock. So if property had been bought or sold during the course of the year, etc. And as we've seen, those are referred to as brought forward in the 1994 letter. And there were two representative ones of these in the bundle below, including the one at page 68, which is for 2001 to 2002, and therefore prior to our agreement. And the only point I take you to for that is on page 69, where one sees the various amounts. One notes the account numbers, then sales, i.e. brought forwards, and then voids, so 3.5%. That's the same figure as we then find in the 2003 agreement. And then commission 9.3%, again the same figure. And one notes that the voids figure is taken off before the commission, which again is consistent with the 2003 agreement. And so the purpose of doing this is simply to seek to make good based upon what limited historical documentation we have, and pretty much we provided the court below and this court with everything that we have, as to what the long-standing relationship was prior to 2003, in order to seek to make the point that really there was no change in 2003.
But can you really make a substantive point? For example, on these figures at page 69, about the voids at 3.5% and commission 9.3%, would have been the most natural thing in the world to carry forward a negotiated figure of this kind. Why would they be expected just because of the particular relationship between them defined in the 2003 agreement? Why would they be? What would commercially compel them to have to negotiate a different figure?
No, my lord, but that's not my point. My point is that the 2003 agreement has the same figures.
I know.
And if we are right on what those things were for under the 1977 agreement, then when one looks at 2003 and there are the same figures, The court says, firstly, well, can we get anything at all from the previous agreements? If we can, what? It is that there was the same commission at this rate, at 9.3%, for the same services, i.e. the obligation to collect from the tenants. And although that's not set out in the 2003 agreement, of course, when one looks at that agreement, that 9.3% commission has to be for something. And it is the same percentage and the same term as has been used since 1978, and the same percentage directly before the agreement.
I mean, are you saying there's an implied term of the 2000 agreement which requires Kingston to do what?
My Lord, I'd have to say that there's implied term. Well, it is, if we are right, the commission is based upon an obligation to collect, then there would have to be an obligation there.
To do what?
To collect charges, obligation and authority.
Best endeavours, reasonable endeavours,
Well,
demand. What is this term? What is the obligation? Reasonable skill and care.
I wouldn't. Well, if the court is satisfied that the commission was referable to that, and it did impose an obligation to collect, then one has to do the best one can, upon ordinary principle of interpretation, to cast a term. If one can't, then we lose.
What do you say the term is?
That the authority was required to collect the charge from tenants and had authority so to collect.
So, if it failed to collect the charge from a tenant who either couldn't or wouldn't pay, it would be in breach?
Well, in theory, it would be in breach, but there would be no loss because the parties already determined that the amount payable to the water undertaker was set by the agreement. And so it took the risk itself.
But you phrase it as an absolute obligation.
Well, I mean, I do that in terms of seeking to demonstrate its agency. If it was purely giving authority to collect, but not an obligation, then it may be said, well, that in and of itself could not amount to an agency. It might be acting on behalf of. And that's the only reason I would say that one would need to have that clause, purely to make it a true relationship of agency. But if, in order to make it agency, there is simply a requirement for authority to collect, then that would suffice.
I mean, there are plenty of agencies in which the agent doesn't actually have to do anything to earn his commission, which estate agency is the obvious example. The commission is payable if the estate agent makes a sale or finds a willing purchaser, but hasn't actually got to do anything.
But I think probably more, the better way of putting it is that I would say there has to be an authority to collect. And that's probably as far as I do need to go, because it's implicit that the nature of the deal is that even if you don't collect, you will pay all of these amounts. Not necessarily you have to have authority to collect. And we would say that that would arise by necessary implication. I apologise, but I don't need to go as far as I had suggested. Well, anyway, those are the materials. Then, in terms of...
we just don't know. This is one of the troubles. We get this all the time with very sophisticated financial agreements, with dozens and dozens of lawyers working night after night. And you don't know what terms they actually own. They don't overlook them, but they're prepared to give them away or they hold them back. For the court to try to reconstruct what would have been sensible for them to have done won't necessarily give you the right answer. For example, one possibility, who knows? One possibility is that under the 2000 agreement it was not considered by Kingston to be sufficient compensation to be paid the fixed amount for administration, for example. And so there was some discussion about boosting that up with something called a commission. We just don't know.
Arnold, all I can do is to look at the preceding relationship over many years.
Yeah.
The fact this agreement, although completed in January 2003, related back to the 1st of April, so intended to reflect what the parties had been doing for the previous 9.5 months.
Yes.
But not only that, affecting the rights of third parties, namely the various tenants. They're seeking to demonstrate that really what they were seeking to do here was write down, not enough, but trying to make it a slightly more formal form, what had been left on a very, very informal basis for decades.
Yes, I'm sorry to sound sometimes, from the bench, it can sound terribly negative. I'm doing the usual thing of testing the case.
Yeah, of course.
That's all. I'm not expressing a view about the outcome. And I certainly understand, as you put extremely clearly to us, that the previous arrangements were an agency, and that the commission was for certain because they had to do as an agent. It was an agent for commission that continued throughout the whole period, and that these features you told us in particular find their way into the 2003 agreement. I mean, I understand all of that.
Well, I'm grateful, and I can't take that any further. Yeah. Look, can I then turn to the specific grounds of appeal? I'll try and deal with these as briefly as I may.
Yes, please, thank you.
The first ground is that the judge gave two reasons for why the prior agreements offered no use. And the first was that they weren't identical, and prima facie, that reflected a deliberate decision to depart from the wording of the previous agreement. And secondly, that the arrangements from 1977 to 8 were against a different statutory scheme. My Lord, in the bundles we have HIH casualty, where Lord Justice Briggs dealt with the use to be made of prior agreements. I don't need to turn that up unless my Lords wish me to. I accept entirely that what he said is they're always admissible, but a cautious and sceptical approach is required to finding any assistance in the earlier contract, and that's a sound principle. And he gave, he did say that in the generality of cases, it is impossible to say the parties didn't wish to alter the terms of their bargain, and where there's a difference, prima facie, it's a deliberate. So I accept all of that as I must. But what we do say is that when one looks at the previous documents, in particular the 1977 letter, the core terms of the previous agreement and the core terms of the 2003 agreement are materially the same. And in our skeleton argument, at paragraphs 37 to 45, we undertake a clause-by-clause analysis, which I therefore do not repeat.
Thank you.
But in any event, we say that even if we're wrong on that, the reference to commission of 9.3% in clause 3.2 being the same as the same percentage prior to that does enable one to say, even if other terms of the agreement may have been different, what the commission was, the same percentage, it was for the same thing. And we would say that suffices. And we accept everything the Lord Justice Rick says, but one gets that, nonetheless being cautious and sceptical, looking at the prior bargain predating. The second reason the judge gave was that the...
Can I just ask you a question, going back to the question I asked earlier, and I apologise if this is going over old ground. But would you accept that it's necessary to your argument on this ground that the arrangements, to use a neutral word, that were in place prior to the 2003 agreement were in fact an agency relationship?
On this, yes. If I'm relying on agency, yes, I would.
Yeah.
If I'm relying on the alternative acting on behalf of, assuming it exists, then I would say I simply need to show that.
I see. Thank you.
But yes, because it's necessarily part. It is in my case that nothing changed. So that, my Lord, that must be right. The second reason given was that the statutory schemes were different. That's right. They were different, but they were materially the same. In that, as I say, even in 1978, one had the charges scheme. One had the distinction between primary liability and the ability to make an agreement with a third party, and one had the existence of the powers to collect by local authorities. And secondly, in any event, when Thames Water Utilities came on the scene in April 1990, the agreement then was the same, and the statutory provisions under the 89 Act were the same as the 91 Act. So we say the judgment was wrong for those two reasons, not to accept this interpretation. And then there's the third point that we've made already about the fact that the 2003 agreement was stated as having retrospective effect. So if we're wrong on all of that, then ground one ends. if we're right, then one has to say, well, what assistance did the prior arrangements give? And my Lord already has my submissions that when the parties used the word commission of 9.3% in clause 3.2, they must have meant something. And once one looks back at the prior arrangements, one sees what they meant, and that is the meaning that should be given to it. And then, similarly so, that provides the proper explanation for clause 4.6 and the requirement to pay VAT. And if one has it in that way, then that provides a far more suitable and reasonable interpretation of clause 4.6, because it actually operates because there are services being provided, than anyone about, oh, well, it's put in there just in case the VAT man takes a different view or things are changing. So that's ground one. Ground two only arises if we're right on ground one. And if we are right, then there are express clauses in the 2003 agreement which are inconsistent with it being one of the provision of services by Thames Water and are consistent with it being a contract of agency. Therefore, one has to, on usual principles, work out what ultimately is the form of this agreement. There are three particular formulations. Either it is the provisions of services, as the judge found, or it's agency, or it's agreement for collection and recovery on behalf.
And the contraindications which you rely on are the description of commission and the VAT clause.
Yes, it has to be. Yes. I mean, I can't get any more from the agreement than that. And in terms of matters that one has regard to, I mean, I have to accept that if the court takes the view there's really nothing about the terms of the agreement that speak of anything but full purchase, then very strongly that is going to be. But if there is a reasonable doubt because of these two provisions, allied to the 1977 agreement and the position, then there has to be a choice made. One has to work out what the parties intended, and that is where we do say that the statutory background to the agreement becomes relevant. Now, we have to accept that we need to demonstrate that the provisions upon which we rely must have been reasonably available to both parties. If they weren't, then just tough. And here we would make the point that the 2003 agreement was made by the statutory undertaker itself and a local housing authority. The fact that it made express reference to the Water Industry Act in Recital 2 and to Section 143 and the charges scheme in Clause 2.3, and that it was directly about charges for water and sewerage services to domestic premises and the payment for them. And we submit that what would have been available, reasonably available to the parties, are three things. Firstly, the primary statute itself, the 1991 Act, including Chapter 1 to Part 5, which is concerned with charging. Secondly, the 2001 order made under Section 150 within this chapter. And thirdly, the express statutory powers conferred on local authorities to enter into agreements for collection and recovery on behalf. Now, I think the only one I need to deal with expressly is the Water Resale Order. I think it must be, I assume it's accepted that the general statutory provisions would be available. Now, so far as...
So, can you just help me? Because I've always had a bit of trouble with this concept of reasonably available.
Yes.
Because obviously, if you're dealing with some piece of background that it's clear was in fact known to both parties, the question doesn't arise. So the question only arises if it can't be affirmatively shown that part of the background was not in fact known to the parties. Now, and this is quite a good test case of the proposition, because this is available in the sense that anybody could go and look it up. It's a public document. But is that enough?
Well, I'd say it isn't enough, because in that case, anything's available to anyone. My Lord Justice Lewison has made the point that the fact that things are available on the internet doesn't mean they are readily available.
Right. So what is the true test?
Well, what part point to here are I'd rather give factors than, if I may, at first. The first is that there was a duty on the director to publish it in such manner as was considered appropriate for the purpose of bringing it to attention of persons to be affected. So there was a positive duty to publish. Secondly, there can't be any issue but that Thames Water must have known about it because it was the undertaker itself. So far as the local authority, we are dealing with a local authority, not an individual. And it is an authority which is responsible for thousands of its own tenants and has been demanding and recovering water and sewerage charges from them for decades under the water legislation. And it also has a range of regulatory and enforcement functions in relation to private sector housing, including houses in multiple occupation. At the time the agreement was made, these functions were contained in Part 11 of the Housing Act 1985, and as my lord will recall, the Water Resale Order, as one of the 4 categories, reserved expressly to HMOs. And in addition, the other point I made, it was also the licensing authority under the Caravan Sites Act 1960. Added to which, of course, as a local housing authority, it is in the business of providing housing advice to those in the private sector about tenancy issues they may have under its general housing powers. So when one is considering a contracting party such as this, a public body with statutory functions in this area where this order is going to be relevant and where it's entering into an agreement under which it is then going to charge its own tenants for charges, we say that this order, made under the primary statute in the same part of the Act where express reference is made, would have been reasonably available to it. I haven't given a test, but I've given factors that I say it means in this case it would suffice. And if we're right on that, then the 2 points we say, deeply uncommercial for my client. And secondly, and perhaps more importantly, a big change for occupiers. That on the 13th of January 2003, rather than being charged as they had been for decades under the charges scheme, suddenly, as a matter of law, required to be charged under paragraph 5 of the 2001 resale order. We say very unlikely the parties would have intended such an unlikely consequence. Well, the final point of this submission, the final point of the background, is additional consequences that would flow if this is an agreement as the judge characterised it. And there are 4 particular rights which would be lost for the tenant occupiers if this is an agreement for provision of services by Thames Water. I think we summarise these very briefly in our skeleton argument. Would you like me to take you to them?
Perhaps that's the best way of doing it.
I'm grateful. Well, it's the Authorities Bundle Tab 8, and it's the Water Industry Act 1991. And if you can pick it up, page 59, please. And section 50, sorry.
So which paragraph?
It's page 59 of Tab 8. And we're within the 1991 Act. I didn't go to these earlier because they would have
Okay, fine.
And so section 52 is the domestic supply duty. And that's a duty in relation to any premises to provide to those premises a supply of water which is sufficient for domestic purposes and to maintain the connection in the undertaker's water main and supply pipe by which supply is provided to those premises.
Sorry, you said page 58?
59, my lord.
59.
Sorry. Right, so that is the domestic supply duty, and it's a twofold duty as set out in section 52, 1A and B. And we see from section 54 that that duty is owed to the consumer. That's on page 62 is section 54. And consumer is defined by section 93 on page 66. And that definition is consumer in relation to supply of water provided by a water undertaker to any premises means, except in Chapter 4, a person who is, for the time being, the person on whom liability to pay charges to the undertaker in respect of that supply of water would fall. And so if this is an agreement for provision of services to my client, the tenant ceases to be the consumer on that date, and therefore this duty ceases to be owed to him. The second duty, my lord, is page 63, and they're all the same point, they're all the consumer point. Section 60 empowers a water undertaker to disconnect a service pipe or otherwise cut off a supply if it's reasonable for disconnection to be made or the supply be cut off for the purpose of carrying out any necessary works. And subsection 3 provides, except in an emergency, there must be reasonable notice served on the consumer. And then, where these works are done, subsection 4, there are duties owed to the consumer in terms of reasonable dispatch, etc. Then, breach of the duty, subsection 5, which causes any person to whom it is owed to sustain loss or damage shall be actionable to suit that person. So again, this wouldn't be owed to any of the 4,500 olds of Kingston. Then the penultimate one is section 62, that's page 65. And this concerns the disconnections at the request of a customer, and the ability to give a notice requiring disconnection can be made only by the consumer. That's the foot of subsection 1. So again, they can't seek disconnection. And then finally, page 87 is section 144, capital A. And this is the right of a consumer who has an unmeasured supply to request a meter. And again, the ability to request a meter is owed only to the consumer. You see that from subsection 1. So again, if this is an agreement, as the judge said, these 4 rights are lost by the consumer, by the tenants, without notice. They're substantial rights. Again, we say that's unlikely to be intended. So, Lord, those are the matters of background that we rely upon. And we say that if one does have regard to them, in addition to the express terms of the agreement, plus what we said about the meaning of commission and VAT, when one does come to interpret what the parties truly intended, difficult though it is, and difficult as though some of the language is for all interpretations, the proper interpretation is a contract of agency and not one of supply to Thames Water. If we're right on that, there is no need to consider the alternative where we put it, namely whether or not there is some form of sui generis argument of collection on behalf. I've already made my submissions as to why such an agreement is capable of existing. The reason we, of course, rely upon that is because it is in case the court takes the view that the agreement did not have sufficient capabilities to be a contract of agency. And we put it very simply here, that the undertaker provided a service to unmetered properties. It was bound to charge those occupiers and bound to charge them in accordance with its charges. The local authority was the owner and manager of all those properties, collecting rent on a weekly basis for decades. And if the undertaker and the authority agreed that the authority would be responsible for collecting that identical charge from the occupier, as the undertaker would otherwise have been down to do, we say that simple arrangement is an arrangement for the collection and recovery of the charges on behalf of the undertaker. It does not need to be sophisticated. It does not need to have any formal requirements of agency. It is an agreement born of mutual convenience where one does the collecting rather than the other. And because it's one of collecting on behalf of, no one loses out. The tenants retain all of their existing rights. The undertaker is the same. and therefore there's nothing offensive about so regarding it. Well, that's ground 2. Grounds 3 and 4 follow with her right on that. We wouldn't be an undertaker. That then just leaves ground 5. I don't know if my Lord wishes me to deal with that now.
No, I think not. We have the other argument from Mr. Westgate
Okay,
on the
Lord,
principle.
unless I can assist you further.
Any further questions? Any further questions? Thank you very much indeed. Yes, Mr. Westgate.
My lords, the short answer to this appeal is that the judge was entitled to reach the conclusion that he did, paragraph 93, that the agreement clearly states, or the 1993 agreement, clearly states that it's an agreement for Kingston to pay Thames Water for the water and sewerage services provided to Kingston. If that's right, then, as I understand it, it's saying it's accepted that the Water Resale Order would apply, and one doesn't need to get into the remaining definition. And the appellant's argument depends, as the judge recognised, you say, on going significantly beyond any recognised process of construction. In particular, and as has become apparent in the course of this morning, it goes well beyond interpreting what particular terms of the 2003 agreement means. It's not about seeking to understand the language of the contract. Instead, what the court is invited to do, building on the edifice of the proposition that the word commission must mean something, the court's invited to rewrite the agreement by ignoring its subject matter, what the judge found its principal subject matter, which was payment by Kingston for services, and instead inserting provisions to the effect that Kingston provided a collection service in consideration for the payment of a commission, and as the appellants accepted this morning, you have to include in the agreement an obligation on the part of Kingston to collect the charges from the tenant.
Mr. Bowes slightly reserved from that. He said it was sufficient that there was an authority to collect.
But that won't do with respect, because if it's simply an authority, it's very hard to see what the consideration is. If he's going to say that Kingston provided a collection service in consideration for the commission, he can't stop at authority. And an obligation of that kind is not only impossible to define, and so would be something which wouldn't be implied, but it's wholly absent from the wording of the 2003 agreement.
Well, it's not impossible to define it. I think your real point is it could be defined in all sorts of different ways.
No, yes. So perhaps I should have said it's impossibly uncertain, in the sense that what the court can't do is alight on the one that the one of the options that the parties must have met. But in any event, to get into that exercise isn't interpretation. To get into that exercise is implication and rewriting. And the appellants don't rely on any authority to suggest that the process of construction and interpretation can lead you, because you read one term as meaning something, that then leads on to implying a term, still less implying a term of this significance, which is the one which, according to the appellant, changes the entire meaning of the contract.
So you say the foundation for the argument on an implied term is the very thing that he's seeking to prove.
Yes.
The only basis on which you could say there's an implied term here is if you assume that commission is indicative of agency.
Well, certainly the whole thing starts from the assumption commission must mean something.
Yeah.
But as the cases are very clear, the use of assertive language like that can't be decisive, and certainly can't point you only in that direction. So the appellant's argument depends on reading words into the contract, which simply can't be done by any recognised principle of interpretation. There's some other kind of exercise of amendment or reading in or modification or implication. And so whatever else can be said, that there is simply an unbridgeable gap between the wording of the 2003 agreement and what the appellant seeks to achieve. The appellant doesn't explain how, other than an appeal to an implication which, with respect, he had difficulty formulating, doesn't explain how that insertion can be achieved on the language of the agreement. And instead, in various parts of his submissions, and this is perhaps more in the skeleton argument than it was in his oral submissions today, he invited the court more generally to construe the nature of the agreement as agency, or the nature of the agreement as on behalf of, without really specifying how you got to that from the terms of the agreement. And again, that's not interpretation, that's classification. And the starting point really is to work out what does the terms of the agreement mean. And as Mr. Bose accepts, as I understand him, he can't really, simply on the language of the agreement, depart from the clear analysis of the judge. And on that analysis, that produces no difficulty. It gives, and the resale analysis gives effect to the words of the agreement that the parties have chosen, and doesn't require any violence done to the language. Nothing needs to be deleted, nothing needs to be inserted. One simply applies the language of the 2003 agreement. And that is, on the language of the agreement, an unsurprising outcome when one looks at the statutory scheme. I leave aside for the time being the points made about section 150 and the consequences of that. But in terms of the way in which the scheme of the Act operates, so as to make somebody who's not the occupier the person to whom services are provided, that flows very naturally from the way in which the agreement is expressed, and it flows from the language of the statute. We set out the provisions of paragraphs 10 to 11 of our skeleton. I'm not going to take you to them, particularly in the light of the comments made by Master Rolls at the beginning of this appeal. But the headline points are that the water industry is highly regulated, and only water undertakers can use the supply and sewerage systems that are in place, and then they have a duty to maintain a supply of water, and we saw that in the domestic supply duty, and effective sewerage. And so it follows that the becoming a reseller can't involve the reseller doing anything in relation to the physical infrastructure in order to effect the supply or to receive the supply. In effect, all they can do is pay for the service, and that assumption of responsibility to pay makes them the recipient for the purposes of the Act, and one sees that reflected in the definition of consumer in section 93 and 150B, and it also fits in with the power to charge in section 142 and the identification of the persons to whom services are provided in section 144. And again,
Mr. Bose's point was that if Kingston is the person to whom the service is supplied and then resells it, it is Kingston rather than the inhabitants of the various dwellings who are the consumer.
that would follow.
You accept
Yes.
that?
Because the definition of the definition of consumer and indeed customer is the person to whom the liability to pay attaches. And Mr. Bose took you to some examples as to why he thought that might cause some difficulty. I'll deal with those when I come to that part of the submissions. But way in which Section 142 works is that it empowers the undertaker to fix charges and to demand and recover them from persons to whom it provides a service. Section 144 defines the occupier as the person to whom the service is provided, and except where some agreement provides to the contrary. And since the power to charge can only arise in relation to someone who is the recipient of services, if you agree to pay on your own behalf, you become the recipient of services. Otherwise, there'd be no power to charge you even by agreement. Although the wording of the 2003 agreement, we say, clearly does indicate the provision of services to Kingston, it wouldn't actually need to go that far. It would be sufficient if Kingston paid on its own behalf. So what I propose to do, my lords, is to deal with what the correct approach is here, and I think deal with this fairly swiftly, because that's the question, whether you ask about is Section 150 fulfilled, or can one arrive at that by asking, is this an on behalf of arrangement, which appears to be what Mr. Bose's approach is. So it's the sui generis point. Then I was going to deal with the judge's approach very briefly, and then in the course of doing that, then go on to deal with Mr. Bose's grounds 1 and 2, which I think will broadly cover most of this part of the appeal. So if I can deal first of all with the proper approach.
How long do you think that will take?
About an hour.
Thank you.
So far as the proper approach is concerned, the respondent's case in substance, which was accepted by the judge, is that the way to approach the question in issue in this case is to ask, what does the 2003 agreement mean, and does that then fall within the definition in Section 150 in the Water Resale Order? The appellant's approach, or the appellant's question, is to, certainly in their skeleton argument, perhaps less so in their oral submissions, was to ask, well, is the arrangement one which is on behalf of, for the purposes of what's now paragraph 20 of Schedule 1 to the Consolidation Act 1991, and then to say that that produces the answer to the question whether or not Section 150 applies, because those two arrangements are mutually exclusive. That is, we suggest, the wrong way of approaching matters, because it involves, as the judge found, asking the wrong question.
You say they could have entered into such an arrangement. The question is, did they?
Indeed, and the point, it may well be, as a matter of fact, that most of the kinds of arrangement you can think of that fall within paragraph 20 won't amount to resale agreements, because if they are genuinely on behalf of, that normally calls to mind agency, and agency won't be the same as sale. But the more expansively one looks at the terms collect and on behalf of, then it becomes obvious that if you construe on behalf of in a very wide sense as simply meaning for the benefit of, something like that, then, and as my Lord Justice Lewison pointed out in argument, if you substitute the term instead of or in place of, then you might come to the conclusion that someone who is a reseller is collecting charges instead of the local authority, instead of the water undertaker. But that doesn't mean that because it's got into paragraph 20, that it's therefore excluded from the definition in Section 150.
In other words, it's not necessarily the case that the two are mutually exclusive.
No, indeed. And the short proof of that, we would suggest, lies in reflecting the fact that one could have a water resale arrangement with a private individual, and a housing association included. But on Mr. Bose's approach, if that agreement was entered into and could in some way be categorised as on behalf of by the local authority, then it couldn't be a Section 150 agreement. If it was entered into by a private individual or a housing association, then it could be. And indeed, you might have the very same agreement having that dual character because the local authority might transfer their housing stock to a housing association, in which case the day before the agreement, the transfer, the agreement would fall outside Section 150 on Mr. Bose's argument, and then when it gets transferred to the housing association, it would be within Section 150. That can't be what's intended, and one can't gather any intention from the Act that these two types of arrangement are mutually exclusive. As Mr. Bose has demonstrated, the on behalf of power was one that's got a long pedigree, that's undergone a number of changes over the years, and it would be very surprising if mutual exclusivity was to be gathered from something which appeared first in, which at the time that the predecessor of the Water Resale Order arose, the on behalf of provisions were in paragraph 40 of Schedule 25, minor and consequential amendments in the 1989 Act. Section 82 of the Act dealt with what's now water resale. There's no reason to think the two are fundamentally connected.
Is that a convenient point?
Yes, I can finish this point off in a couple of sentences.
Certainly.
So that's what we say about exclusivity, but in fact, although Kingston persists on the mutual exclusivity point, given the way they express their disagreement with the judge, it doesn't appear to have any practical significance to this appeal, because they don't appear to rely on any features of the 2003 agreement or its predecessors that won't get them home on agency, but will get them home on behalf of. They didn't appear to identify any additional features. So I was then going to go on to the judge's approach and the criticisms of it.
Moment. Very good. Thank you very much. 2 o'clock.